Welcome to today's webinar on post-judgment collections. Our speakers today are Jared Allen and Mario Lamar of Allen Bryson PLLC. I want to go over a few items before we get started. Should you have any questions today, please use the Q&A function located in the bottom center of your screen. If you have a PIN, I will provide you with the course number, and it's been approved for 1.0 hour of CLE credit. That course number is 174084853. This course ID is also noted on the PowerPoint and will be provided again at the end of the program. In order to receive CLE credit for today, you must self-report with the State Bar of Texas. I will now turn it over to Jared and Mario.
Thanks, Sherry. Thanks for the introduction, and thanks to all of you for joining us today. My name is Mario Lamar, and I'm here with Jared Allen. And our law firm is Allen Bryson. Go ahead, Jared. Sorry.
No, it's okay. Thank you all for having us today. My name is Jared Allen. Mario and I will be giving you the presentation today. A little bit about myself before Mario gets started. I worked in Dallas for about 7 or 8 years. I came into Longview. I've worked here for about 10 or 11 years, so we've been doing this. I've been doing different types of debt collection for, I guess, on and off for 18 years. We do a lot of oil field collection, different type of collection cases. We obviously handle them from beginning pre-judgment all the way through post-judgment. So Mario is I've seen a lot of lawyers come and go. Mario is one of the best, especially at doing a lot of this collection work. So I know this could be like a fire hose today. If you have any questions, you can always contact him, contact me. But I guarantee I'll learn something today as well as y'all. So I look forward to it, and I'll let Mario take it from there.
Well, great. So we're here today to talk about post-judgment collections. So where we are in the life of the lawsuit, of course, is you have your judgment. And today is all about taking that judgment, that piece of paper signed by the judge, and turning it into money for your client. So I'm going to begin with kind of an overview of what we'll be talking about, as well as some strategy tips in collecting your judgment. So starting out with strategy, it might be a little cheesy, but it's important to be relentless when you're collecting your judgment. By definition, you're dealing with a debtor who does not want to pay your client. In some cases, they might not be able to, but generally speaking, they are choosing not to pay your client, and you have to force them to come to the table and to pay. So it's important to find the leverage that's going to get the debtor to pay, and it's important to always be taking next steps. And that's what I mean by be relentless. You should always be taking your next step in the collection process. So if you send post-judgment discovery and you don't get a response, well, file your motion to compel. So just always be taking that next step and that will force the debtor to come to the table. A couple caveats about our discussion today. We're going to be talking mostly about commercial debt, debt collection practices. If you have a judgment for consumer debt, you're going to need to obviously follow the guidelines and the rules in the Fair Debt Collections Practices Act and Texas version of the same statute. So there are going to be some additional things you need to keep in mind when you're collecting a consumer debt that we just won't get into today. And then finally, Jared said it's going to be like a fire hose. It's going to be a lot of information once I start to talk about different collection techniques and tools out there. But still, I mean, I can talk about writs of execution probably for an hour just by itself. So I'm not going to be able to cover everything you need to know for filing and dealing with your first writ of garnishment or writ of execution. But there are some excellent how-to guides out there. Dorsanio's litigation manual, it's always great. He has a lot of good step-by-step ways to collect your judgments and use these different tools we're going to be talking about today. And then another really good resource, how-to guide, is Donna Brown. She's the post-judgment collection queen. She's out of Austin. You can find a lot of her articles online. So those are some good how-to guides to use some of the tools we'll be talking about today. So today we're going to be talking about two general topics. One is debtor investigations, that's asset and liability investigation, and 2, different tools for collecting your judgment and how to go about that process. So first we'll talk about debtor investigations, and this is an important part of the judgment collection process because you can't go out and seize assets and file your writs of garnishment unless you know what assets exist and what liabilities exist. So a lot of times lawyers will just look at assets when they're going to try to collect a judgment, but it's just as important to look at the debtor's liabilities as well. So that's things like deeds of trust filed by the bank, other judgments, UCC liens, mechanics liens. You want to look at all of the liabilities as well as all the assets that that belong to the debtor. As far as when you want to conduct your debtor investigation, I recommend, and it's my practice, to do an investigation at the front end of the case. It doesn't need to be super heavy-handed, but it will allow you to advise your client on what the debtor might have or might not have, and it will allow you to know what kind of a debtor you're dealing with as well. And then, of course, as the case wraps up, as you get your judgment, you again need to do a more thorough asset investigation to see what is really out there. So when talking about debtor investigations today, I'm going to go over some general debtor search tools that I use, more specific tools, and then post-judgment discovery. And with the reason I talk about general search tools and specific search tools, general search tools are going to be kind of the casting a wide net, so to speak, stuff that will allow you to get a ton of information about a debtor and their assets and their liabilities. And then specific search tools are those tools that are going to allow you to then find the specific information on a particular asset so you can go and have that asset levied on and then sold. So general searches, when you're actually conducting a general search to try to find assets and liabilities, probably the best tool, and if you're doing this on a day in, day out basis, you should definitely do this, is a subscription software. Lexis and Westlaw offer different softwares. TransUnion is a big one that a lot of collection lawyers use. And then IDI Data is a newer one that I know a lot of lawyers use as well. But what a subscription software will allow the lawyer to do is you can type in the debtor's name, and with a single click, you're going to get a ton of information on their assets and their liabilities all in one place. So it really saves you a ton of time. And then you can take that information and go do a more specific search and go find assets based on what you find in the general search. The types of information generally provided, it's going to be everything from the debtor's assets or from the debtor's addresses, the real property that they own, as well as vehicles. If the debtor has vehicles in their name, you'll be able to find the principals if it's a company. A lot of times, if it's a company, they'll have annual revenue as well. And then you'll see all kinds of different liabilities. UCC liens, if they've been filed, if the debtor's filed bankruptcy, that'll pop up in the search, as well as other judgments out there in mechanics liens. So all of that will be included in a single search. So it just saves a lot of time. As far as I know, there is no single search option for any of these different subscription providers. You do have to just have a subscription, whether it's annual or monthly. I know TransUnion offers one service for $50 a month, which I think is pretty reasonable. I don't know what all you get with that, but so that's some really good subscription services that you can use to find information on debtors. One service that I use that I'm sure y'all are pretty familiar with is the Secretary of State page, SOS Direct. I will use SOS Direct, of course, to look at the entity, the business, if it's a business debtor. And then I will also use the search function to look at each of the principals and see what other businesses are out there owned by the same people. And depending on the industry, you can find out a lot about how the company operates and how the different businesses kind of operate as one. For instance, in the oil and gas industry, a lot of times the oil operator, it'll be one entity, and then the working interest owner, which in essence is the entity that owns all the assets. It owns the leases and the real property. That'll be a separate business, but the principles will usually be the same. So use the individual search function when you're looking at this stuff. Oh, go back. And then UCC liens, you can also find UCC liens on the Secretary of State page, and you can search debtors and see what UCC liens are out there. And UCC liens are going to be liens against the debtor's personal collateral. And a lot of times, if you find an old UCC lien in the Secretary of State page, the collateral will be listed. So, and if the UCC is no longer valid, then the lien will no longer be in place, and you can go after that collateral. So that's how I like to use the Secretary of State page. Corporation Wiki is another good option that will provide essentially a map of all of the different entities related to the same principles. So you can see how businesses are connected, and it helps you kind of figure out where the money goes and how the business as a whole operates. A great tool that I love to use is texasfile.com. Essentially what TexasFile does is it accumulates all the different county property records out there and puts it into one place. So there's a state search function on TexasFile where you can search all of the county property records in Texas for $5 for a single debtor. So you'll get an index. You won't be able to actually click on the documents themselves, but you'll get a listing with volume and page number, and usually some kind of legal description for all of the things that have been filed by the debtor in the property records. So deeds of trust, warranty deeds, liens, judgments, you'll see all that stuff. And so it's a really good place to start. And then you can take that information and narrow down and find pieces of property you actually want to go collect on. The next link is research.texcourts.gov. This is a new one. It's been around, I don't know, maybe for a year or two, and y'all may be familiar with it. But this is essentially, I think it's run by eFile, and you can use your eFile password and log in to get in. But it accumulates and puts together all of the different court information out there in Texas for district courts and county courts as well. So if you're dealing with the debtor, you can go search and see how many other lawsuits are they involved in. And that's a good tool just to see, are there a bunch of other judgments? Are there a bunch of other lawsuits going on? I will also use it in cases where I want to get in touch with the debtor, but they're not answering my calls. I don't want to just try to take a quick default. I actually want to talk to someone and try to work out something. Usually if the debtor owes you money, they owe someone else money. There's probably a lawsuit out there. And if the debtor is represented in that lawsuit, then you can go in using research.texcourts, find out who their lawyer is and contact that person and try to get the ball moving towards a resolution that way. And usually the defense counsel is happy to hear from you because it usually means more business for them. Pacer is another good tool. I'll use Pacer just to make sure that the debtor hasn't filed bankruptcy. And then of course, Google social media. Those are always good for finding information about debtors. Specific searches. So now we're talking about, you've done your general search, you have kind of an idea of what is out there with the debtor, what kind of assets, generally speaking, and liabilities exist. With specific searches, you really want to narrow down and look at specific pieces of property you want to collect on. You want to have levied and sold. So with texasfile.com, I've already talked about the state search function. There is a county search function that is completely free to use. again, you'll just see the index. You won't be able to click on the documents, but it's a really good place to start, especially if you know a debtor is operating in a particular county. You can go see what all property they have as far as the property records go for that county. Countyrecords.com is similar to Texas File. I think County Records does a better job when it comes to actually listing out the legal title. And so the index that they provide, it's also free, and it is a little bit more comprehensive. Whereas Texas File, sometimes you have to purchase the documents to really look at the legal title of the property that's involved. And then county official records, a lot of counties, especially the bigger ones, keep their official records, their property records online. So with this function, and I include some of the free options out there, Bexar County, Gray County, Harris County, you can actually go and click on the warranty deed, the specific document you're looking for, and you can view it, and it's free. So that's a really good resource. If you have a debtor in a bigger county, you can usually go look at their specific property filings without having to pay any money. So that's a really good resource if it exists in the county that you're investigating in. And then appraisal district websites, those can be really good if you're trying to figure out, obviously, the value of an asset. As far as figuring out ownership, they can be, you probably shouldn't rely on you definitely shouldn't rely on what's in the appraisal district website, because usually it's just the taxpayer who's listed as the owner. And a lot of times the taxpayer isn't actually the title owner of the property. So use the appraisal district to determine value, but not ownership. And then if you have a case where you think intellectual property might be involved, the debtor might have some IP, the USPTO website, you can search patents and trademarks. And then if you have an oil and gas case, Texas Railroad Commission website has a ton of information. I mean, you can find out all the oil and gas being produced by an operator, find out what leases they own. You can see drilling permits, all kinds of great stuff. And then finally, some more obvious options out there, but always keep in mind, you should check the case file before you go off and start trying to collect a judgment. There may be checks from the debtor in the case file that you can use to go then get a writ of garnishment. And then you should also talk to your client before you get into the weeds on a collection, judgment collection. A lot of times the client will have specific information on the debtor that you just don't know about. There's been situations where the client has called us and told us about assets that exist that weren't filed in the property records, and we were able to go collect on that stuff. So, and then finally, if you know about specifics and you want to get a PI involved, a private investigator, that can be a good option if you are looking for specific information. I think just to get a PI to generally find out stuff, probably a waste of money. Okay, so I'll talk really quick about post-judgment discovery. There's a reason this is last in our debtor investigation discussion today. And that's because a lot of times post-judgment discovery isn't all that helpful in getting you information to help collect a judgment. Post-judgment discovery can be helpful in other ways, though. A lot of times it's good for making the debtor work, and that can be as effective as anything else in getting a judgment paid. But otherwise, we use post-judgment discovery usually to obtain specific information about a particular asset, or to make the debtor work, like I said. Requests for admissions, those can be really good for proving up turnover receiverships. So we'll talk about turnovers later on, but there's certain elements required for a turnover receivership. And if the debtor doesn't respond to your RFAs, then obviously those will be deemed admitted, and you'll be able to prove up your turnover receivership with those RFAs, those admitted RFAs. So you can do something similar too with garnishments. And then request for production, if you're looking for a specific document on an asset, maybe it's not filed in the property records, maybe you can't find it elsewhere, then RFPs can be good for that. ROGs are good for making the debtor work. And then depositions are a really good tool. It's good for making the debtor work, but it's also good for finding specific information. And it forces the debtor to actually think about the case for a few hours while they sit across from you. And instead of, hiding and avoiding talking to you, avoiding dealing with discovery, they have to deal with the debt and the situation. A lot of times too, we'll set our post-judgment depositions for the debtor's offices. They think you're doing them a favor because it's way more convenient for them, but you're actually going to be able to go into their offices and see what kind of assets they have. So that can be a pretty effective tool for getting a judgment paid. And then when the debtor doesn't respond, always be ready to file a motion to compel, seek sanctions in your motion. Monetary sanctions typically is what we do. And as far as we have a boilerplate motion to compel, motion for sanctions ready to go. And so if the debtor doesn't respond to discovery, we go and file that motion to compel. As I said before, always be taking the next steps in this process. And that's going to be what ultimately forces the debtor to come to the table. And if the debtor doesn't comply with the judge's order on the motion to compel, then you can go file your motion for contempt. So, those are some ways we like to use post-judgment discovery. Okay, so now we're going to be talking about the actual tools for collections. This is the second part of our discussion today. And again, I'll take a step back. Big picture, you have your judgment, you've done your asset investigation, and now you want to use the different mechanisms that are out there to go collect those assets and turn your judgment into money for the client, into recovery for the client. So these 5 tools on the slide, these are the most effective tools that I've found in our practice to get judgments paid. And the first 3, abstracts of judgment, writs of execution, and foreclosure, those are really 3 steps in a single process. So you're going to file your abstract of judgment, then you go out and use a writ of execution to levy on the specific piece of property you want sold, and then you sell that property at a foreclosure sale. So that's really 3 steps in a single process. Garnishments and turnover receiverships, those are 2 just additional ways to collect your judgment, 2 different tools entirely. Okay, so start by talking about abstracts of judgment. You guys are probably at least somewhat familiar with abstracts. What an abstract of judgment does is it creates a lien on all the debtor's non-exempt real property in the county where it's filed. So it's extremely important to take your judgment and abstract it. The reason why is because it will give notice to other creditors that the judgment is owed to you. And it also creates what's called a judgment lien. So by virtue of having your judgment, you don't have a judgment lien until you file your abstract of judgment in the county property record. And again, you need to do that for every county where you think the debtor may have non-exempt real property. And from a practical standpoint, we file abstracts of judgment in any county where we think the debtor has any kind of property, real property or otherwise, just to be safe. And I will file it in any county where I think the debtor is operating as well. So the abstract of judgment is important because it will determine priority for which creditors get paid first. So if, for instance, you don't file an abstract of judgment, you get your judgment today, you don't file your abstract, another creditor gets a judgment 3 years later, they do abstract their judgment, and some assets come up. The other creditor, even though they took their judgment 3 years after you, they're going to be entitled to priority to those assets in that county. So it's really important to abstract your judgment right away. As soon as you get your judgment, go get your abstracts. The process for getting an abstract of judgment, it's extremely simple. You make a request to the court. The court clerk will generally prepare an abstract of judgment. You should request however many abstracts you need. So you make sure to do your asset investigation first, figure out how many counties you're going to be filing your abstracts in, and then make your request to the court clerk. They will prepare the abstracts of judgment, send them to you, and then make sure the contents are correct. The contents required for an abstract of judgment, they're found in Texas Property Code 52.003. Make sure the information that the court clerk puts in the abstract is correct as well. I can't tell you how many times I've had to go back to the court clerk and have them make changes. And it's on you as the lawyer to catch those issues. So make sure the contents meet 52.003, make sure the information is correct. And once it is, then you can take each of those abstracts and file them in the counties where the debtor has non-exempt real property or other assets. Abstracts of judgment, they're going to be necessary, generally speaking, for your writs of execution and for your foreclosure. And that's why I talk about this as being the first in the three-step process. And then the life of your judgment lien, it's going to be 10 years from the date that it's recorded in the property records. So 10 years from the index or recording date, that is the life of your judgment lien. You can extend it an additional 10 years with the issuance of a writ of execution. So if you get a writ of execution, once it's issued, that will extend the judgment lien another 10 years. Once the judgment lien becomes dormant, there are two ways to have it revived. So the 10 years has expired, either 10 years from the recording date or 10 years from the issuance of the execution. You can have it revived in a 2-year window. So you only have 2 years in which you can have that judgment lien revived. You can do this one of two ways. One is by filing a writ of surfacius, which basically revives, you file that in the original case, and it's going to revive the original judgment. The other option is you can file a new action of debt, which is going to be an entirely new lawsuit, but based on the underlying judgment that you've already obtained, and then the court issues you a new judgment. So again, you have to take one of those two revival actions within 2 years from your judgment becoming dormant. If you don't revive the judgment during that time period, the judgment is going to be forever barred. So it's really important to calendar this stuff and watch out for these deadlines. As far as that goes, there are some immortal judgments that do not die. An example is a judgment for child support. Okay, so the second step in this process is of finding the debtor's assets, abstracting your judgment, and then levying on those assets and ultimately having them sold. The second step is your writ of execution. So the writ of execution, what it is it's a sheriff's levy on all the debtor's non-exempt property in the county. So the purpose, the reason to do a writ of execution is to have the debtor's property levied and essentially seized. The reason the statute uses levy is because a lot of times you're not physically possessing the property, the sheriff's not going to, and so levy is more appropriate. But you can use a writ of execution to go and levy on real property as well as personal property. And the issuance for writ of execution is 30 days from the judgment date. Generally speaking, you have to wait 30 days from the day you get your judgment before you can get a writ of execution. There is one exception, really two exceptions. You can get a writ of execution earlier than that 30 days if the creditor or their attorney files an affidavit stating that one, the defendant is about to remove non-exempt property, personal property, or two, the defendant is about to transfer or hide personal property. If one of those situations occur, you can get a writ of execution issued within that 30-day window after getting your judgment. So how do you go about getting a writ of execution? Again, like an abstract of judgment, it's a really simple process. You make a request to the court. Before you make your request, you can do it in a letter. Typically, an email would probably work as well. But before you make your request, you want to look at Rules of Civil Procedure 629 through 633. 629 has the general contents required for a writ of execution, You know, the writ's got to be styled the state of Texas, directed to any sheriff or constable in the state, et cetera, et cetera. It needs to describe the judgment. But there are some additional requirements in 630 through 633 for specific kinds of writs. An example is a writ related to money judgments or a writ for the sale of particular property. Those are going to have some additional requirements. So when you make your request to the court, you want to make sure the court is aware of that so they can prepare your writ of execution properly. So again, that's rules 629 through 633. Check those out before you make your request for the writ of execution. And then also in your request, you want to specify whether the officer needs to return the writ within 30, 60, or 90 days. Again, that's going to be in the statute, but I will typically ask for 90 days. And that's just because 90 days is a longer period of time in which the officer and you will have to sell the property. So if you do 30 days, you set yourself up where you may have to ask for an extension. So once you make sure that the court clerk will prepare the writ of execution, and then you want to make sure the contents are correct, again, pursuant to the rules 629 to 633, and then you will have the writ delivered onto the sheriff or constable. You want to make sure the writ goes to the correct precinct for where the assets are going to be levied on. And that can be a little messy. A lot of times it takes some phone calls and just figuring out which precinct is going to be handling the levy and which constable's office is going to be handling it. But in Dallas, for instance, there is a map online you can find, which makes it a little bit easier. So before the sheriff goes out and levies on the property, you want to try to get a good relationship, a good working relationship with that sheriff or constable. Talk to them about the specific assets you're looking to have levied on. Talk to them about their process. The constable's office has a different process depending on where you are in the state, and they're going to do things differently depending on what type of property you're looking to have levied on. So I always talk to the constable ahead of time. So once you send that writ of execution, give the constable's office a call and get to know the person who's going to be exercising that writ. So the levy process, when the constable actually goes out to levy on the property, it's going to be different depending on whether personal or real property is involved. If personal property, if you're looking to levy on personal property, generally the constable will go in person. And if the debtor is entitled to possession, the officer levies on that property by taking possession of it. If someone else is entitled to possession of the property, then the levy is made by giving that person notice. And again, this is for personal property. If bulky, large personal property is involved, you can use labels, locks, or even a bonded security guard to levy on the property as needed. We've levied on frac tanks before, and what the sheriff did in that situation was just put labels on the frac tanks. And they itemize that, and the sheriff will know if somebody comes out and removes it. But there are situations where you might want to have a security guard actually keep watch of the property. And if you're looking to have real property levied, it's actually a lot simpler. The levy is just done by endorsing the levy on the writ, on the actual writ of execution, and that's in Rule 639. So when the sheriff levies on property, whether it's personal property or real property, the sheriff needs to give the defendant the option to designate which property is going to be levied on. And that's in Rule 637. The defendant has that right. And again, when I say rule, I'm referring to rules of civil procedure, unless I state otherwise. So Rule 637 has that requirement. And so make sure your sheriff's aware of that. I know I've had cases where the sheriff didn't know that was required. The sheriff needs to give the defendant the option to designate which property will be levied on. A lot of times the defendant will refuse to do that, and the sheriff can go forward with the property that you want them to levy on. And also where the defendant does select property, but it's not sufficient to satisfy the judgment, the sheriff can levy on additional property as needed. And then finally, one final note on writs of execution. go with the officer where possible to have the property levied. Go with the sheriff, go with the constable, because that is a really great moment of leverage in your post-judgment collection case. My first writ of execution was at a used car dealership on Harry Hines, and I went with the constable. The debtor was irate about the judgment, really didn't understand what was going on. I explained to him we were going to take a couple of his vehicles. I had a tow truck coming, and he begged us for a couple hours to get together the money. And the sheriff luckily had some time, and I did too. And the debtor was able to come up with the full amount of the judgment and got us a certified check that afternoon. So go with the sheriff. It's a good opportunity to just, put pressure on the defendant, on the debtor. So I did see we have at least one question. I'm going to try to get to questions at the end. If I don't, feel free to reach out to us. We'll have our contact information at the end of the slideshow, and reach out with emails or phone calls and let us know if you have any questions about any of this stuff. Okay, so now we're on the third step of the process of actually selling the debtor's assets in order to satisfy your judgment. You've abstracted your judgment, you've had the property levied on using a writ of execution, and now you want to have the property sold at a foreclosure sale. So the foreclosure process is going to be a little bit different depending on whether you're looking to have real property or personal property sold. With real property, it is going to be sold at the county courthouse door in the county where the property is located between 10 a.m. and 4 p.m. on the first Tuesday of the month. And the court can order that the sale occurs on site at the location of the property under Rule 646A, depending on the circumstances. So there's been situations, for instance, where we wanted to have the foreclosure sale on site. An example was a saltwater disposal well. We wanted to have that sold on site because there was some additional personal property equipment that we wanted sold as well. And so we just made a motion to the court, and the judge granted that. I think the judges generally will allow you to sell real property on site as long as it makes sense, as long as it's you're not trying to do anything underhanded. Real property, the sale of real property in a foreclosure, it requires publication. You have to publish a notice in the newspaper in the county where the property is located. You have to do that once a week for 3 consecutive weeks. And the first publication has to be at least 20 days before the sale. So once a week for 3 consecutive weeks in a newspaper in that county, and then first publication at least 20 days before the sale. The contents of your notice are going to be found in 647, and the officer, the sheriff or constable conducting the sale, they're going to prepare it, make sure to request a copy, and ensure that all of the contents in 647 are included before it goes over to the newspaper. And then you're also required to give the debtor's attorney notice of the sale, and that notice must conform substantially to what's in 647. So the notice that you put in the newspaper, essentially you need to send the same thing to the debtor or their attorney, and you'll satisfy that requirement. One last thing to keep in mind with selling real property, you want to try to line up bidders for the sale ahead of time. So you can work with the client to do that. The client generally will know the industry. They'll know maybe some other people in the industry who are looking to get this specific piece of equipment or real property. And you can work with the sheriff as well to find bidders. But while you're doing that, it's important to remember each county has different requirements for bidder eligibility when it comes to real property. So call the county ahead of time and see what the bidders need to do in order to be able to purchase the property. Usually it's just a statement from the county tax office saying that the bidder doesn't owe any back taxes, but it's important to know that ahead of time. So if you are working with bidders and bringing bidders to the sale, they know what to bring with them. so that they can purchase the property. And whatever that county requires, it's going to be required in order for the bidder to actually, get the sheriff's deed. So make sure to look at that ahead of time. Okay, so when you're selling personal property, as opposed to everything else I've been talking about, that's foreclosing on real property versus personal. When you're selling personal property will be sold at the premises where taken, or the courthouse door, or some other place if it's more convenient to exhibit it to purchasers. A lot of times that other place will be the constable's office. So this is all set out in Rule 649. The bottom line is you have a lot more flexibility with where the sale is going to occur when it comes to personal property. The sale of personal property also requires notice on the courthouse door. Your notice of sale must be posted for at least 10 successive days immediately before the sale at the courthouse door. So 10 days successive before the sale and at the courthouse door. And you're also going to need to post notice at a place where the sale is going to occur. So if the sale is going to occur somewhere other than the courthouse, you need to also post your notice at the place where the sale will occur. And that's in Rule 650. So then one other tip for selling personal property, and it's not required, but just a good thing to keep in mind. If you're trying to increase bids, which of course you are, you will want to maybe post a classified ad describing the personal property for sale in a newspaper in that county ahead of time. A couple other just quick notes on foreclosure sales. When you submit your writ of execution, so step 2 in this process, when you submit that to the sheriff, make sure to include order of sale language found in Rule 309. That's just a good practice to have. And then the sheriff or constable, they're going to generally prepare the sheriff's deed, but check with the county beforehand, check with the sheriff. Some counties do expect the lawyer for the creditor to prepare the sheriff's deed. And then make sure your sale occurs within the life of your writ of execution. Remember, your writ of execution is going to request that the sheriff deliver it back within 30, 60, or 90 days. And the reason I request 90 is so you have more time to get the sale done. But make sure that sale is going to occur within the life of your writ. Otherwise, you can grant an extension, or you can request an extension under Rule 647. Creditors, generally speaking, have the right to purchase with credits, with judgment credits. And the way that works is the judgment creditor will be at the sale, and they can credit their bid on the property against the judgment. So if you have a forklift, for instance, up for sale, you can the creditor can purchase the forklift for $5,000. They don't need to have cash on hand. They can use their judgment credits, and then if they are successful in their bid, they get the forklift for $5,000, and their judgment will be essentially deducted, will be credited $5,000. So you want to make sure the county allows creditors to bid with judgment credits. Most do, but call ahead and make sure. And then also talk to your client before they make a bid, because they're going to be bidding subject to all liens. They're going to be taking that property subject to all liens. So a lot of times it's good to either have a title company or you yourself do some title research, see what liens are out there, and make sure this is the real owner, who the debtor is the actual owner of the property as well. You don't want your client to bid on a piece of property and wind up with a huge headache. We have about 15 minutes left. I'm going to kind of run through exempt property and by saying that businesses in Texas, corporations, there are no asset exemptions. Individuals have a ton of asset exemptions, homestead, lots of personal property. We are a very debtor-friendly state, but those exemptions don't apply to businesses. At any rate, you don't want to wind up with a wrongful execution. Make sure that the property you're levying on is not exempt. So just something to think about when you're going to get your writ in foreclosure. Okay, so we're going to talk about writs of garnishment. This is an entirely separate tool to satisfy your judgment. What a writ of garnishment is, it is essentially you are capturing funds owed to the debtor by a third party. And this is most commonly used with banks, but you can garnish other pieces of property as well. Examples include safety deposit boxes, past due promissory notes, shares of stocks, etc. There are certain exemptions to garnishment. And again, these are generally speaking only going to apply to individuals, not businesses. But wages are exempt from garnishment with one huge exception. They are not exempt once they're deposited into the earner's bank account. So essentially they're exempt in the employer's hands. Once the earner has those wages and deposits them in their account, the wages are no longer exempt and you can garnish that account and get a hold of those wages. Also, compensation due to independent contractors, those are not wages and therefore they're not exempt. So two important things to remember there. Workers' compensation benefits, those are exempt. Welfare and social security benefits, also exempt from garnishment. There are others, but yeah, and you can find those in the statutes. So your legal requirements for getting a garnishment, it's 3 elements. You have to have a valid judgment, and that judgment needs to obviously be owned by the judgment creditor. 2, you cannot have a supersedious bond filed by the debtor. And 3, the creditor must swear that the debtor possesses no assets in Texas sufficient to satisfy the judgment. So, and that's sufficient to satisfy the entire judgment. So how do you go about getting a writ of garnishment? One final thing I'll note on the requirements. From a practical standpoint, you also need to know where the debtor banks or some other third-party garnishee that you're going to go after. A lot of times people think you need to know the specific bank account to do a garnishment. You don't. You just need to know where the debtor banks. You don't need to know specific account information or anything like that. And you can find out where the debtor banks usually by looking in the file. Either the client has received checks or a wire payment, and a lot of times you can find out the bank information through that. Or you can use UCC liens. A lot of times the UCC lender will be the same entity or bank where the debtor banks. So those are just a couple of ways you can find out where the debtor banks. Okay, so how do you go about getting a writ of garnishment? It is a separate lawsuit and it's going to be filed against the third-party garnishee. So I'm going to use that synonymously with bank. Third-party garnishee is typically a bank, not always. When I say bank, I'm really talking about third-party garnishee. So you file your separate lawsuit against the bank. It's going to have a separate cause number, and it's going to be brought in the same county and court where you got your judgment. You go about doing a writ of garnishment by filing an application for writ of garnishment. It's going to, essentially the application is just going to include those 3 legal requirements that I talked about before. And then you're going to include an affidavit attesting to the facts, those same 3 legal requirements. I generally prepare my own affidavit. I'll make the affidavit for my signature because I have personal knowledge about the legal requirements, the valid judgment, the no bond, and that there are not sufficient assets to satisfy the judgment. So once you have your application for garnishment, you have your affidavit, you're going to serve those things you're obviously going to file that with the court, and then you're going to serve the garnishee with the application and affidavit. The court will issue a writ of garnishment, and you also want to make sure that's served on the garnishee as well. After the garnishee gets the writ of execution, and not beforehand, then you serve the debtor with the application, the affidavit, and the writ of garnishment. Do not serve the debtor before the bank gets the writ of garnishment, because otherwise the debtor can go into their bank account and take out everything. So you want to make sure the writ of garnishment is served on the bank before you serve the debtor with the writ of garnishment and the application for writ of garnishment. No bond is required in Texas for a post-judgment writ of garnishment. So that's one other thing to keep in mind. No bond is required for post-judgment garnishment. And then finally, once you serve the bank, the process is really going to play out one of two ways. Either there's going to be sufficient funds in the bank account to go to you, the creditor, or you're going to drill a dry hole. There's not going to be enough money to go to you. And so you're really only able to capture, this is something that I didn't understand until I did it. You're only able to capture what's in the account when you serve the garnishee with the writ of garnishment. So you're not able to get anything after that point, generally speaking, only because the debtor is not going to be dumb enough, at least in my experience, to put money into essentially what is a frozen bank account, because they know that money is going to go to you. So once you serve the garnishee, there's either going to be money in the account or not. If there's no money in the account, you want to go ahead and file a non-suit as soon as possible. And the reason you do that is because the garnishee is entitled to their attorney's fees. So the bank is entitled to attorney's fees. That money will come out of what's in the account. If there's nothing in the account, then you as a creditor will be expected to pay those attorney's fees. So from a practical standpoint, the garnishee, the bank, they're going to get with you, their attorneys will get with you once they receive the writ of garnishment, and they'll tell you what's in the account. And they'll tell you, look, file a non-suit, and I won't request attorney's fees, and that'll be the end of it. And then if there is money in the account, usually you will use an agreed judgment with the bank, and the bank will agree to turn over those funds to you minus their attorney's fees. So that's kind of how it plays out, practically speaking, once you serve the writ of garnishment. Okay, so the final thing we're going to talk about today is a turnover receivership. This is essentially the granddaddy of collection techniques. Turnover receiverships are like your Swiss Army knife of collection tools. And essentially what you're doing here is you're getting a receiver appointed to collect and sell all of the debtor's non-exempt property. And you can have their property sold throughout the state. It's not limited to the specific county where you're getting the receiver appointed. And the requirements to get a turnover receiver, there has to be one property that cannot readily be attached or levied on by ordinary legal process, and two, that property has to be exempt. So as far as the exempt part, that's a straightforward element. But then when it comes to property that cannot readily be attached or levied on by ordinary legal process, that's a little bit more nuanced. But generally, it's going to include intangibles such as accounts receivable. It's going to include contract rights, property that can be easily hidden, shares of stocks, rights to distribute, or right of distribution, property outside of Texas, internet domain names even, and even bank accounts are probably going to be considered not readily leviable by ordinary legal process, because garnishment and or turnover, those are considered extraordinary legal process by the courts. So that element will essentially support your turnover receivership. And I've had receiverships explain this to me as essentially all you need is one difficult to reach non-exempt piece of property, and that will open the door wide to all the other assets of the debtor. So all you need is one piece of property that is not readily attachable or that cannot readily be levied on. And you can go use the turnover receivership to get all of the debtor's non-exempt property in the whole state. So it's a really great resource. The turnover receiver, their powers are extremely broad. It can last indefinitely. With a certified copy of the order of receivership, the receiver can garnish accounts. They can have all non-exempt property turned over and put into the receivership. They can lock out the debtor. They can obtain information from third parties. There's some case law disputes on that, but for the most part, that's allowed. They can levy on proceeds from a lawsuit, and transfers after after the order, the turnover order, are signed, those are void, not just voidable. So extremely broad powers. And how you go about getting a turnover receivership, all you do is file a motion for turnover receiver. You need to prove up those two elements. You'll include an order for turnover receiver. That'll have your turnover receiver's information in it. And then a hearing is required under the statute. And at the hearing, you'll prove up the two elements required. So then from a practical standpoint, you want to talk to your receiver beforehand. They're going to help you prepare everything. They're going to help you prepare the motion for receivership, your order. I use, at least in Dallas, I use Mike Bernstein. He's great. He's a good turnover receiver. The receiver's fee is going to be 25% of all proceeds brought into the receiver's possession. So 25%, and that is treated as a court cost to be taxed against the defendant. So what that means is if you get the judgment amount and 25% on top of it, your client's going to still be entitled to the entire judgment amount, and the receiver will be entitled to 25% in addition to that. Now, if there's not sufficient assets to cover all of that, then the 25% of the receiver, they still get paid, and that'll come out of whatever is recovered. Some receivers assess a dry hole fee, and typically there's not a bond required for turnover receiverships. If there is a bond required, and it's a court-by-court basis, it'll be a nominal amount, $100 or $200 usually. Okay, that's really that's turnover receiverships overall. And I know we got a couple questions. It looks like I have 2 minutes. Okay, I'm gonna, if you guys want a copy of the slideshow, or if you want to see notes or anything that I did to prepare for today, I'm happy to share that with you. I'm happy to share the slides with you as well. Please just shoot us an email. Our email address or email addresses are provided. If you have any questions, feel free to call us. We're always happy to talk about post-judgment collections. And then the course ID there is provided on the slide if you missed that. A couple tiny things. Today's presentation, it's hosted by the Solo and Small Firm Committee of DAYL. It's actually going to be a part of a series. So this is the first, and I think a 3-part series. We're going to work backwards. There'll be one presentation on trial practices, and then I think one on preparing a petition. And then finally, there's a happy hour for the Solo and Small Firm Committee tomorrow at 6. Email me or Sherry if you want the link to that. Okay, well, thank you all. I really appreciate your time today, and I hope this was helpful.